Good afternoon and welcome. I'm Ben Osman-Suri, Senior Attorney with the Unemployment Law Project. The Unemployment Law Project has been around since 1984. We are the only freestanding legal aid office in the country solely dedicated to unemployment. The Unemployment Law Project provides free advice and counsel and free legal representation to people in Washington State who have been denied unemployment benefits or whose award of benefits have been challenged. We're here today with our weekly webinar, which occurs every Monday at noon. During this webinar, we will share the latest news on unemployment benefits, as well as answer your questions during our presentation and through your question submissions in the Q&A chat box. I'd like to introduce our speaker today from the Unemployment Law Project, Staff Attorney and Policy Director, Ann Paxton. I will now turn it over to you, Ann, to get us started.
Thank you, Benos. Welcome to our weekly webinar. We're glad to announce that today is October 26th, and that's an important day because it means that in 2 months, the deadline will be hit for applying for pandemic unemployment assistance benefits, which is a very important deadline, which I'll go into a little bit more. But I wanted to give some general updates about what is happening. First, just a quick overview on what's happening with benefits trends and projections. So obviously nationwide, a large number of workers are going to see their benefits running out very quickly. And that's even despite, they're going to be, a lot of them have already neared their maximum benefit under the PEUC program and are well into their extended benefits. The PEUC program will run out at the end of December. So even if they haven't used up all of those benefits, they will no longer be available. So what's the distressing trend is that the number of long-term unemployed in the country has kind of massively grown. In August, it was at 1.6 million. And by September, it had risen to 2.4 million. That's the largest month-over-month increase ever recorded. So we're starting to see some statistics that are bearing out what we've been guessing, which is that this is historic and unprecedented levels of unemployment. The seasonally adjusted number of long-term unemployed workers grew massively in September, and this is expected to continue. And that's been especially hard on minorities, Black workers in particular, who have a much higher unemployment rate than white workers in general. As everyone knows, the Congress added through the CARES Act a 13-week extension called the Pandemic Emergency Unemployment Compensation, PEUC, which has had several problems in implementation in Washington State. In addition, it's expected to run out at the end of the year. Extended benefits add 20 weeks. We'll see, but again, we've heard of people already approaching the end of those benefits as well. So without congressional action to extend the CARES Act, PEUC and the POA program into 2021, that means millions of workers will be dropping to zero benefits just at the time. So there's been some new developments in the area of delay in claims processing and in processing of appeals. So overall, over 1 million Washingtonians have applied for, have been paid some unemployment benefits. There's been far more applications than payments, but there are still thousands that have not been paid. One of the big problems is with appeals, because people who've been denied or are at some phase of the application process where they've got a negative decision and file an appeal are not being heard for a very big range of reasons. One is that some of the questions are difficult to send directly to OAH, the Office of Administrative Hearings, to be presented to a judge, because the questions are not necessarily the kinds of issues they would normally deal with. So ESD has chosen to deal with many of those with redeterminations in-house. In addition, the staffing at the Office of Administrative Hearings is far, far short of the level of judges that will be needed. In September, the Employment Security Department liberated 8,000 appeals that they had been trying to redetermine and could not. So the ones that they did not redetermine were sent to OAH, but OAH does not have enough judges to deal with that many in a month. They were only able so far to schedule 2,800. So that's going to be a continuing source of delays as more appeals come in every day. The level of delay or lag time that the Employment Security Department has claimed is happening is about 60 days to process an appeals request, but we know of many people for whom that process has been 3 months, 4 months, and even longer. When that appeal is getting to the Office of Administrative Hearings, it's often taking 30 days or longer to get it scheduled for a hearing. But we're seeing, last week we heard from the chief judge at OAH that in one day, 700 appeals were delivered to OAH from ESD. So part of that bump of the python has moved from ESD to OAH, but that doesn't necessarily mean that people are going to see a swift resolution of their issue. We have heard about several people who've had substantial payments because of issues that were resolved after many, many months of requests and pleas, and sometimes in the region of $15,000 to $20,000, with all of the back pay going back to February in some cases that they were due from PUA. So right now, the OAH is saying that even though they're at 100% capacity, they've hired extra judges. They have a total of only 50 judges who can do about 6 hearings a day. So you can do the math. If there's thousands of appeals coming in, chances are not good that that's going to be disposed of very rapidly. There are some timeliness standards that the Department of Labor enforces, and it has certain penalties that it can impose, mostly on the Employment Security Department if those timeliness standards aren't met, but those have been long fallen by the wayside, and we're not expecting action on that front. So aside from the delays in claims processing and the delays in appeals transmittal, we have found that in the process of that happening, ULP has found its traditional role altering a little bit. Well, one alteration is we're doing weekly webinars. It's certainly nothing we ever did before because, like everyone else, we're trying to adjust to the realities of the pandemic and all of the issues that's created. But ESD normally, the Unemployment Law Project normally has advised claimants who are having difficulty getting their claims processed or have an adverse decision to appeal. And that's what we normally do. We help people with their appeals. They're heard before a judge. We try to get them a resolution to get them their benefits when they're owed benefits. But what's happened this year is that there's been a sort of very unfortunate merging of the applications process and the appeals process. One example is that ESD, which is supposed to just handle claims processing, is now taking care of a lot of the appeals with redeterminations. So that's one issue. The other issue is the big backlog that has of appeals that have never made it to the Office of Administrative Hearings. And along the way, people are having all kinds of adverse decisions in the applications process. So if we tell them, as we traditionally have done, that they should appeal, often that sends them into a very unfortunate black hole. We're not to blame for that. They're not to blame for that. It's just the system is unfortunately overwhelmed, and that's what's happening. So we've been having to get a lot more involved in application issues. And I wanted to just talk about 3 of those today that have been very distressing to discover. I'm sure claimants individually could probably give us quite an earful about the problems they've encountered, but unfortunately we don't get much access. We can see the screenshots that ESD has of how claims processing works, but we can't actually access the claims application ourselves. So even through kind of a dummy application process. But one things that we have discovered have to do with problems with the availability issue, application questions on availability. Another one is a mysterious notice that people are getting about their benefits being reevaluated. And a third that I want to mention is an overpayment notice. Many people have received these threatening notices, which are very distressing, obviously. And then I want to talk about what kinds of things we're trying to do about it. So first with the I have an example here of one of the more disturbing issues that have arisen on the application, and that is answering questions about availability. So this is kind of a running theme for our webinar and questions we received from claimants, which is, well, the job search requirement is suspended. So why do I have to be available to work? There are some respects in the context of the PUA requirements in which people do not have to be available. Technically, they don't have to look for work or be available to take a job if they were stuck without daycare, had to take care of a child because of COVID, or had somebody in the house that was ill with COVID. If they had a directly COVID-related reason, they would not technically have to be available. However, on the application process, they must still say they're available. This is an unfortunate thing because essentially they're being given a sort of a distorted version of this question. It says, on the application process, it says, are you physically able to work and available for work? That's under your occupation. So if you have to stay home and take care of children who can't attend school because of COVID, or because somebody is sick in your family, then your inclination would be not to lie. Your inclination would be to say, no, I'm not available to work. And that should be an exception. However, if you do that, it's a trick question, because you're going to trigger possibly a process of adjudication because you've said you're not available to work. You have to be available to work under all traditional standards of unemployment benefits. But many of those we thought were suspended this year. They were suspended this year. But unfortunately, in the application process, that's not happening. So people are very, very sadly being tripped up and sent into sometimes, as they call it, an unemployment abyss. And this is just one example. Another one is the question that is another one that has been very difficult for people, and we don't really actually know how to answer it ourselves, is when people are in the middle of filing an application, and they're asked if they want to reopen a claim. And then they're asked about whether it's do you want to reopen an active claim, which is a tricky question to answer, because that might be a claim that they haven't been using. Maybe they were approved many, many months ago for a PUA, for example, but they're getting regular benefits now. So it's not an active claim, but technically under ESD rules, it would be considered an active claim because a year has not gone by since that claim was opened. So they can technically reopen it, causing a lot of confusion on that score. And of course, the classic one for everyone is, how do you answer the question, have you made 3 job searches this week? Are you actively looking for work? Everyone knows that there's a job search suspension at least until November 9th. And the word has been constantly, until further notice. There is no requirement that you search for a job. So what if you say no? Well, that's what the advice that ESD is explicitly given. You can say no. However, that is not working for many people. There seems to be several avenues inside the application that controls the platform for applying for benefits that just won't take that answer. And again, that's causing people to get sent down this rabbit hole from which they're having a hard time emerging. Second one I wanted to mention is the mystery evaluation of benefits letter. So I've seen many of these, but it's the first time I've been able to isolate one without identifying information, so I can show it to people, and people can see for themselves just how tricky this is. This says, we made a decision about your unemployment benefits based on, sorry, I'm being blocked here. Based on information we have at this time, we reevaluated your unemployment benefits starting, in this case, February 2nd. This update was due to a change in at least one of the items below, and there's 5 items listed here. So it could be anything. Determination of a new issue, redetermination of an old issue, determination of a monetary decision, and so on. If we need to consider other questions about your claim, we'll send you separate letters to address each issue. Unfortunately, they're not going to be any more informative than this letter. Under the CARES Act, individuals who are eligible for regular UI can receive an additional $600. This is called PUC. If you were denied a full week of benefits under your regular UI, you are ineligible for any PUC for that week. So they're explaining things that could be going on here. And at the end, it has maybe something to do with lost wages assistance, which was the temporary assistance program. Let me go back one. And at the end it says, so these are all possibilities that this letter could be about. It's just an open form letter with a very vague, very vague point to make. You can appeal this decision if you disagree with it. Well, claimant after claimant has come to us and said, where's the decision? I can't find it. And all of the lawyers in our office have the same reaction. We cannot find the decision because this is just a vague form letter saying, we made a decision about something. Here's some possibilities that it could be about, and you can appeal it. Well, you can imagine the frustration, and probably many of you have experienced the same thing, that claimants are feeling when they don't know what to do when they get this letter. And we have a very difficult time advising them what to do as well. So this one has been a real problem. We refer to it as the non-decision decision letter. Continues to be sent out regularly, and it leaves claimants and attorneys alike puzzling about what decision there is to appeal. And there's a variation on this, which I won't go into today, but it's on the application screenshots on ESD's site. And it basically says this statement, maybe it's basically this letter that you hold in your hands right now, or is on your screen, maybe non-operational by the time you read it. So if that's a useful message, we haven't been able to determine what use it actually does have. Another message that it contains, by the way, is if you haven't reviewed your response by the time this letter is sent, the information below is likely wrong. So these are things you really can't quite make up, but this is what claimants are facing. So a lot of real issues with the application process. And again, this is merging with the appeals process. It's getting very difficult to distinguish these. And the final one I wanted to mention is the non-specific threatening overpayment notice. And many people are getting these because of there's audit processes. Everyone knows there was incredible fraud that was going on 4 months ago, and the agency has not quite fully recovered. Has not recovered all the money that was lost. So there has been a clampdown at the federal level as well to make sure that people who are getting benefits are, by their definition, actually eligible to receive them. So this is an interesting notice in as well, because again, it's one of these attempts to solve all problems with a form letter. And this one has certain inserts which relate to this particular claimant who has had a $235 payment that they were questioning. We may have already paid you $235 in unemployment benefits. We must decide whether you were actually eligible. The amount we paid you includes any money we withheld for federal income tax. These are strong messages, because this means you're going to have to pay more than you actually got in pocket. If we paid you too much, you must pay it back, and we can take money from your federal IRS income tax refund, place a lien on your property, garnish your wages and bank account, withhold future unemployment benefit payments. So this is a very scary message. What can you do when you get this? If it was not your fault, helpfully, this message says you can request a waiver, and you won't have to pay us back if it's approved. But the next question is, why do you feel you were not at fault for this overpayment? Which is an incredibly contradictory and impossible to answer question, because the person has not even understood that they in reality owe this overpayment. And the fact that whether they are at fault or not is still not relevant to that issue. So it's basically assuming that the overpayment is legitimate, and that the person knows what it's all about, because there's no information in here saying why they think there is an overpayment. And that makes it extremely difficult to answer the question. It makes it extremely difficult to know whether to appeal, and it makes it extremely difficult to file an appeal. So these are examples of what we've been encountering, and which I know claimants are very familiar with. We see a lot of not intentionally, but just unintentionally misleading advice on, for example, the Facebook support group, saying don't apply for PUA. Well, that is a very unfortunate message, because many people are eligible for PUA. They will get, when their application is approved, they may get many thousands of dollars in back payments that they're owed going back to February, or to whenever they became eligible due to a COVID-related reason. but their applications aren't happening because of a long list of software bugs. I can categorize them that way basically because I think I mentioned in prior webinars that if you, for example, are applying, if you're denied unemployment regular benefits, you'll get a message saying, do you want to apply for PEUC, which is the extension. So if you are denied regular benefits, you are not qualified for the extension. There's just there's no instance of anybody who's been approved for extended benefits without those regular benefits at that point in the process. So the question makes no sense to an applicant. People are going to take the wrong options or answer wrong, and they will never get in many cases, they will never understand that that's the only way they can get to a PUA application. Weird software bug, but it's been sidetracked and sidelined many applicants from getting benefits that they should be receiving. So this is one thing that we're working on top of many others. So we're very conscious of this PUA deadline coming up December 26th. As I mentioned, PEUC, the extension also runs out December 26th, and other benefits do not have that deadline. So extended benefits may continue, regular benefits will still be available as long as you have not hit your maximum benefit amount. So what UAP has been working with some other groups, other parties on trying to address these in a very urgent way, because time is running out and we want to be sure. We believe thousands, if not tens of thousands of people have not been able to get the benefits they're owed. So we've been lucky to be able to hold meetings with ESD. They've been receptive to listening to us. ESD is currently compiling frequently asked questions on the redetermination process, and we're expecting those to come out soon. We know there always have been problems and continue to be problems. For example, when an appeal gets diverted into the redetermination process, it was supposed to save time. What it's doing though is adding an additional initial block of delay that would have been added anyway at the appeals end when it got to the Office of Administrative Hearings. Now, given how overloaded that office is, in the end, it may not make a difference, but we're trying to see if we can get the process to occur more smoothly at every stage instead of having multiple places where it can bog down. So the Northwest Justice Project has been very active in trying to fix this issue with the PEUC, which I mentioned. So they have developed a notice, and they're in the process of finalizing it to help applicants negotiate the software bug. What do you have to do in order to get to the PUA application, despite being sidelined by the PEUC application? There are parts of the application platform questions you have to ignore, and as I've discussed, there are other parts that you have to just pretend they're not asking you that question, that they're asking you a different question. ULP also has its own efforts underway. We're working on flowcharts to help some of these problematic areas, such as the PUA applications and benefit extensions. And we're also aiming to do some translations of the flowcharts into Spanish if possible. We're also continuing to do outreach to and engage the press with this as much as possible. So you can help with this it's very time sensitive and it's extremely important. Please get in touch with us if you have examples to share that you think might help us understand and help us engage further with ESD on trying to get these fixed in a timely way. And also, please convince your friends or yourself if you have not submitted income data appropriate for your PUA application, that is income data from 2019, to show that you qualify for more than the minimum benefit amount, that's $235. Please do it, because time is also running out for that. December 26th is the deadline. Do it as soon as possible. And finally, one random item. When you're on the application page with ESD's platform, make sure you click on the uploaded documents box to make sure that there was nothing that was requested from ESD without notifying you, because that frequently happens. People have just randomly clicked on upload documents and found out the request from ESD came a month or two ago. They didn't get any notice about it. So it seems to occur frequently. And that's an easy thing that some people have found for one niche of the problems that are arising. So we are here to take questions that you have. Some things we won't be able to answer on the spot. We'll have to maybe defer them for later, but please let us know what is on your mind. Thanks.
Wonderful. And thank you for that very informative and useful information and recap. We have a question regarding 401ks. We are seeing a dramatic increase in workers tapping into their 401ks, and there's a question on how to properly answer the information when filing for weekly benefits. And I have a link that I'm going to drop into the chat, but I'll let you start to answer that, Anne.
Great. Yeah, the link would be very helpful because there are several specific items that you do need to mention. They might be deductible from your benefits, but in the case of 401ks, that's a little bit tricky. You do need to report any income that you take from a 401k. If it's money that to the extent that it's money that you contributed to the 401k, you should not be charged. That should not be deducted from your benefit. However, if it's money that your employer contributed, there may be some deduction. So the only way to discover for sure is to report that, and then the ESD will determine it based on the kind of 401k that you have.
Great, thanks, Anne. I did drop a link to the ESD Unemployment Handbook. Pay special attention to page 28, which references retirement. If you do a word search, there are 10 instances where retirement is mentioned, but page 28 starts the major section on retirement. Okay, we have a participant who applied for regular unemployment in April and was denied because of a prior quit on an unrelated job. She filed an appeal in August, and the appeal has not yet been scheduled. In the meantime, in August, the participant filed a PUA claim because they thought they had to be denied for regular unemployment before they could file the PUA claim. They've not heard anything about the PUA claim, and there is no way to file weekly claims on their e-services website. What should they do?
So if the person appealed a denial, they should technically still be able to file a weekly claim. So I'm not really sure what the problem is there. Do you have you had anything occur like that you know of, Benos?
I haven't. My only question would be is if the participant had seen their PEUC question pop up and whether they have applied for that, as Anne just went into detail about. So I would keep a lookout for that. You should be, if you have filed a PUA claim, you should be able to continue filing those weekly claims even while your appeal is pending. And I would say, unfortunately, appeals that were filed in August still have not yet been scheduled. We are looking at late June and July appeals that were filed are currently being scheduled. We do anticipate that ESD will ramp up sending those cases over to OAH soon. But at this point, we're still in a holding pattern. We do recommend that you call the Office of Administrative Hearings to check in periodically to check in and see if the ESD has sent over your docket and your file to OAH.
Right. Thanks, Benos.
Okay. We have a participant who's been receiving unemployment since April. On October 21st, they got a notice that they had been denied unemployment for able and available for work, saying that they owe $9,973 in overpayment. They say that ESD says the participant is being denied because of medical reasons, which makes him unable to work. This is not true. The only reason he's not working is because of COVID.
So you can appeal an overpayment. That I assume, did the person indicate they have done an appeal?
They have not said whether they have done an appeal or not. They just said they'd received the notice on October 21st.
So that would be what we would recommend. File an appeal. You can challenge the determination about your medical reasons and in the appeal. And if you lose that appeal, you can also attempt to get a waiver. That's not to say that it's easy to get a waiver, but that's another avenue that you can do. And that's pretty much what you're limited to right now. It's unfortunately, it is going to be a lengthy process. But you can get, if you call I think it's the Office of Fraud, they can put a hold on your overpayment collection actions while your appeal is pending.
I'm dropping a link in the chat box regarding overpayments, and there is a link and maybe a phone number where claimants can call to request that suspension of the overpayments. The phone number that we originally had is not working, unsurprisingly. So check out the link that I just dropped in the chat box. And I agree with Anne. I would say file an appeal right away. You have 30 days to file an appeal, so I would file it quickly. And ESD does indicate that the best way to file your appeal is through your eServices account. However, if you have trouble logging into your eServices account or you don't see an option to appeal, you may want to send a message through through your eServices account to ESD, and you may want to fax in or hard copy mail in your appeal, just to make sure you meet that 30-day timeline. Okay. General question: if a claimant decides for whatever reason that they no longer want to participate in this ESD nightmare and want to exit the process, what can they do and how?
All you need to do is stop filing claims unless there's something pending that such as an appeal. If you have an appeal pending, you might want to withdraw the appeal. But it sounds like that may not be the case with this claimant. All you need to do is stop claiming.
Okay. And so the claimant would like to know, the participant would like to know if this would be without prejudice or without legal question or procedure, and understand, and they want some understanding that they may be able to reopen their claim within the 1-year benefit period. Is that correct?
Yes. You should be able to reopen it. There wouldn't be a prejudice unless there's some other issue that you're not, that's not being mentioned here. But if you within the 1-year window, you should be able to reopen your claim without problem.
Great, thank you. Regarding an appeal of the overpayment, our legal assistant and colleague extraordinaire, Erin O'Brien, is posting in the chat to everyone that when you appeal the overpayment, you should also make sure to appeal any and all decisions to deny or disqualify benefits and the overpayment decision. Be very specific and clear about any and all things that you are appealing to make sure that all of those are captured in your appeal hearing.
And that's an excellent point, because one of the issues that we're frequently running into is that people who have a positive redetermination, this is people who tried to appeal, ESD snagged their appeal and said, we're going to try to redeterminate in-house, and they got a positive action. But unfortunately, it didn't take care of all the issues that were pending. So they may have been allowed benefits based on that one issue, but they had ineligibility on other issues. In the past, before the most recent IT upgrade, the UTAB system came in 2017, it was very common for ESD to bundle the issues together so that when an appeal went to the Office of Administrative Hearings, it didn't just take care of one issue and then another appeal had to be filed for a separate issue and so on. So we think that's part of the reason that the system has been very bogged down, because they've been splintered off in many cases and unbundled. So claimants are left with a positive decision and no benefits. So that's a very good thing to mention, Erin. Thank you. The people should really try to make sure all of those issues are being sent to OAH so they don't have to go through another torturous process of appeal.
Excellent. Thank you, Anne. We do not have any additional questions in the Q&A box right now, so we'll hang on for a few minutes and let folks submit their questions. Also, oh, we do have a question. Is Lost Wages Assistance Program prorated?
Prorated?
Yes.
I think it just goes by the week. I don't know if they mean breaking down 1 week. I don't think so. I think it's just, there were 6 weeks max of benefits, and those are all taken care of. There's no more money left.
Okay, so the claimant has given some context, and thank you. If they have worked some hours in the previous week, would they receive a partial payment for that previous week?
Well, if they qualified for benefits, at least under the PUA system, and I don't know if this is different with PUC, as long as you had $1 of benefits, then you were able to get the $600 PUC add-on. So if it's being done the same way, and I don't have confirmation of this, Lost Wages Assistance would work that way. If you had just a few hours of work, you should still be able to get the $300 in theory.
Great. Thank you, Anne. And thank you from our participant. Nothing further at this time. Let's see. Okay, very early on, we have a participant who applied for unemployment benefits, UI, with the laid off status, even though they had stopped working due to COVID risk. They were advised by ULP to choose laid off because there wasn't an accurate option alternative. Is anyone having issues with this currently when their cases are reviewed and they check with the employers to see that they weren't actually laid off? So are we essentially hearing from claimants that we've advised to put layoff? Has ESD been reaching back out to these claimants after they've confirmed with the employer that they have not been laid off?
So ESD actually advised the claimant to list layoff as the reason?
The participant is saying that our organization, ULP, has advised to choose layoff because there was not another option. My guess is the participant was either high risk or was exposed to individuals who were high risk and stopped working proactively. Since there wasn't an option that covered that situation, they chose laid off as their status.
Yeah, that's not, I haven't run into that, but that's not to say that it's not happening with a lot of people. Job separation is obviously a huge issue if in appeals. Employers may challenge your benefits. That happens if you say you were laid off when in fact you were fired. The ESD, the hearing or ESD has to determine that there was misconduct in order for the person to be denied benefits if there was a firing. But that's frequently an issue that is contested between employers and employees. So if the employer is contesting it, then that you should be getting a notice of hearing at some point. But again, the delays on that are the same as the delays on appeals by claimants.
Correct, and I agree with that. I think, or if ESD does a redetermination after having checked with the employer and now sends an overpayment letter and says we've redetermined, your employer said you quit, you were not laid off, then in that instance, you would want to appeal within the 30-day time limit. And during the appeal, what may happen either in your hearing or through the adjudication process, it may be determined that actually the claimant was eligible for PUA and not UI, and ESD can reallocate their benefits under PUA. And that may happen absent a hearing, but more likely than not, we'll go to hearing and we'll have the issue resolved either that way or post-hearing. But that, I would anticipate something like that might happen.
So you might attempt, if possible, you might attempt applying for a PUA even while you're appealing the decision. I mean, that can put you in a tricky situation, but if you have a denial of regular benefits, you may qualify for PUA. And it sounds like there's some other factors here that that would have led ULP to maybe recommend putting down layoffs, but I don't know. But I would try to apply for a PUA if you can get. I've heard that ESD has added new buttons offering PUA application, and people are saying, "Why are they doing this?" But other people are saying, "Well, I've been looking for one of those buttons for quite a long time." So again, this is partly rumor and maybe urban myth, but this is what I've heard from people. So I'm hoping it's true that PUA is more of an advertised option on the application platform.
Yes, I agree. And I think if it's not listed, I would also, again, look for PEUC as an option to apply for and potentially send a message to ESD through your e-services account. Great. No other questions at this time, so we'll wait a couple minutes. And as usual, we do like to advise that if you are having issues reaching ESD, it is helpful to contact your state legislators and the governor's office. And I will drop those links into the chat box. Oftentimes, they have avenues into ESD that general claimants don't have. And sometimes those messages do get heard a little bit louder than a regular claimant's message. However unfortunate that might be.
Yes, and if you check in at the support group on Facebook for Washington unemployment, you'll see many examples of people who have found they got some action on their claim or their difficulties with a denial when they contacted their state legislator. So they've been definitely flooded with these requests, but in many cases they've responded. Not guaranteed, but it's definitely something that's working at least some of the time.
Great, thank you. Okay, I did drop the contact form for the Governor Inslee's office and the link to determine your state district and whom your representatives are. Those, you can find those in the chat box. Let's see, looks like no questions right now. We have a number of participants who are expressing gratitude, and our gratitude goes back to everyone as well. Thank you for making these webinars informative. We rely a lot on your questions and the issues that you raise singularly, so we can provide them out to the group as a whole. And we certainly appreciate your participation each week. We'll wait another minute or so and see if anyone else has additional questions before we sign off for the week.
And please just to underline, we are working on these policy issues very hard, especially under the pressure of this remaining 2 months before the PUA deadline runs out. We don't want to see people stranded without benefits that they could have gotten if they had applied in the time frame required. And a lot of it is just the difficulties of the application process, the snags and bugs on the platform, misinformation, and just general frustration that people are having with such a complex process in a very overpressured system. But please get in touch if you have examples or other information that you think would be helpful for us to follow up on.
Great. There is a general thought from a participant that the governor should declare a general amnesty for all claimants and provide benefits to everyone who's applied up to and through December 31st, and then say that they will restart the entire system on January 1st, look for your payments and checks, and you no longer have to submit any claims. Well, that would be fantastic.
It would be fantastic. I'll be sure to bring that up in the meetings with ESG, but
certainly. And participants are welcome to submit those creative and thoughtful suggestions to the governor's office directly. Not seeing any more questions, we will sign off for the remainder of today and be back next week. I would like to encourage everyone to vote. If you have not yet voted, please vote. If you have voted, thank you for voting early. Everyone in Congress and at our state who makes these determinations on how ESD operates, how benefits are allocated, all of these systems are created by people who are elected by us. So share your voice and share your vote, and please vote. Thank you for joining us this week. We'll look forward. Oh, Ann Paxton for president. Excellent. I concur. I concur. Thank you, everyone. We appreciate your participation. We wish you all a safe and healthy week, and we'll see you back here next Monday. Bye-bye.
All right, thanks.